Welcome back. In today's video, we've got quite the mix: 3 self-proclaimed sovereign citizens and a couple of classic Karens. Things kick off in Judge York's courtroom, where he instantly spots a sovereign citizen and wastes no time showing everyone exactly what that kind of nonsense sounds like. Let's dive in.
Ending in 1336. Tell us your name, please.
Dominic Hall.
I come in Sui
Wow.
Jules.
Only one of you actually has that phone number, and the other people are just wrong about what their phone number is. Who's calling ending in 1336?
Sui Juris and personal persona. I'm Stephen hyphen Tyrell colon White comma beneficiary of sovereign. I'm here under fraud, menace, and duress. Fiduciary Daniel Williams Norbeck.
Okay, Mr. White, we're going to pop you over in the waiting room because you're just going to be a distraction for all the citizens here willing to abide by the laws of our country. So we'll pop you over in the waiting room and we'll get back to you. In case you guys have ever heard of the term sovereign citizen in the news, that's what one of them sounds like when they try to come to court.
Beck worked his way through the entire docket before circling back to address the sovereign citizen once again.
Your Honor.
All right. I'm going to read this to you so you understand what you're charged with. This says that on January 7th of this year on 2nd Street there in the city of Fenville, that you were driving while license suspended. That is a misdemeanor. It's punishable by up to 93 days in jail and for $500 fines and costs. Do you understand your charge?
Objection, Your Honor. I do not understand my charges or
okay. I'm going to mark you down as not guilty, and we'll set you for a jury trial. You can continue to.
Your Honor. Your Honor. You practice in front of the bench. You practice in front of the bench. That's my job or my attorney job. I'm sui juris. I'm pro pria.
Okay, Mr. White. I don't know where you read the stuff that you're saying, but it's legal nonsense. It means nothing in a court of law. So if you're not willing to state that you even understand or recognize the authority of the court, my options are I can make you come in for arraignment and not give you a PR bond, and then you'll have to post bond to not sit in jail. You want to do it that way instead? Right now, if I get through arraignment with you, I'll give you a PR bond. Mr. White?
I don't listen. I'm asking you a question.
What's the question, sir?
I'm not arguing with you, Your Honor. I just want you to hear me.
Okay, but I don't want to listen for 20 minutes. Go ahead and ask your one question, and we'll start there and see if it's a real question.
Am I on the record?
Yes.
It's not going to take 20 minutes, Your Honor. I give you my word.
Well, you said you have a question, sir. What's the question you want to ask?
Is this criminal or is it civil?
This is criminal, sir. It's punishable by up to 93 days in jail and or $500 fines and costs.
Hey, if it's criminal, can I ask to dismiss the charge?
You can ask all you want, but it's not happening. This is just your arraignment, not the trial.
Because at this point, the prosecutor, there's no sworn testimony. There's no sworn.
It's because this is just arraignment, sir. What you're talking about is trial. That would be several steps down the road. Arraignment is just for you to make sure that you understand what you're accused of, what the penalty is, and for you to enter a plea. You're accused of driving while license suspended. I read to you what the possible penalties are, and I asked you if you wish to plead guilty or not guilty at this time.
No, Your Honor, I'm a beneficiary and I'm a sovereign. I'm here under fraud, menace,
sir. Those sentences don't mean anything. They have no legal meaning whatsoever.
It's guaranteed by
so
my constitutional.
I've indicated that since you can't understand arraignment, I've entered a plea of not guilty on your behalf. I've set you for a jury trial. You can represent yourself free of charge, or you could hire an attorney. And now you must make a choice, sir, for bond. If we get through the arraignment with you on Zoom, I'm going to give you a PR bond, personal recognizance bond. That means you don't have to post any money. We're essentially trusting you that you'll keep coming back for your court dates. It is no driving without a valid driver's license. If you cannot get that far, in other words, if you really don't understand what's happening here, then I'm not going to allow you to be arraigned by Zoom. I'm going to set you for arraignment in person. And you will come to this courthouse. You will not get a PR bond. You will get a $300 cash or surety bond, meaning that you will need to post $300 in cash, or you will sit in jail from that day until your trial date. So I'll give you a choice. Do you want to be arraigned over Zoom like we're doing today, or would you like to come in and be arraigned in person?
Well, I object to all of this, Your Honor, because at this point, I don't even understand the charges. I do not understand the charges. I'm not trying to.
That's fine. No, sir, you're allowed to. Sir, you're allowed to object, and I understand your sentence that you don't understand the charges. And so I will attempt to work with you for that for a second. I'm going to read the charges to you, okay? This says that it takes place on January 7th of this year. You understand that, right? The date that I just read.
I'm saying I do not. At this point, Your Honor, I was saying this. It was a jurisdiction matter. It's a jurisdiction matter. That's what I'm.
Defendant can challenge subject matter jurisdiction at any stage, even during arraignment, but unless the issue is blatantly clear. A judge won't dismiss the case just because the defendant demands it. Arraignment isn't the time for that.
It's a subject matter jurisdiction.
Here's the problem with you arguing jurisdiction. I am a lawyer, so I understand what jurisdiction means. I'm not sure you do. The accusation is that you're driving around on 2nd Street in the city of Fenville, meaning in Allegan County, and that you're doing so when your driving privileges with Secretary of State have been suspended or revoked. Because this is the county. Yes?
Objection. I'll travel. I don't drive.
Okay.
I have no contact.
Sir, here's what we're doing, Mr. White. You are no longer able to be arraigned by Zoom. What I'm going to do is adjourn this. I'm going to adjourn this, and you will get notice at your address there. You will come in, and we will arraign you in person. I'm telling you that I'm not going to give you a personal recognizance bond, sir.
It has to be before we can proceed.
White,
before you can proceed, it has to be
Mr.
addressed,
White,
Your Honor.
Because we are on the record, I'm going to make this infinitely clear. You're going to get notice to appear in front of me. You have two choices. If you do not appear, I'm going to put out a bench warrant for your arrest. If you do appear, we will have this conversation again about arraigning you to see if you understand the charges, but you are not getting a PR bond. You will need to bring with you $300 cash or surety, or you will be in jail. Do you understand those two options, A and B?
That's a violation of my constitutional rights.
Clear you don't recognize the court's authority. It wouldn't make sense to release you without assurance, so a cash bond is the incentive to ensure you return.
Well, no, it isn't, sir. So we're all set for today. We're done talking. We cannot make any progress. You will be asked to come in person for arraignment. You can either choose to come in for arraignment, or you can choose to not be here. If you choose to not be here, a warrant will be entered for your arrest. And if you do choose to be here, make sure you bring that $300 because you're not getting a personal recognizance bond. But we are done with this hearing. I'm going to go ahead and release you. Thank you.
When's my date for court?
Defendant listened to the judge instead of their online sovereign citizen guru. They'd know their next court date will come by mail. Now, let's head to Judge Slavin's courtroom, where another confident sovereign citizen thinks she knows everything. Next.
All right, you can call Ms. Tubbs' case.
Okay. Following case 2400390201. The people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for competency hearing. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
William Glenn, P36794 on behalf of Ms. Tubbs. Ma'am, state your name.
Beneficiary, Tanea Nicole Tubbs.
All right, Ms. Tubbs, you have a constitutional right to be physically present in the courtroom. Do you agree to waive that right and hold this hearing by Zoom?
I agree.
Okay, thank you. Council, I've received a report dated February 13th, 2025, authored by Andrew P. Sheff, licensed psychologist, consulting forensic examiner. Have you both had an opportunity to review that document?
Yes,
Yeah. Yes, Your Honor.
Do you both agree, stipulate to that being admitted as court's exhibit number 1?
Yes, Your Honor.
And that'll be marked and admitted as court's exhibit number 1. All right, and do you stipulate to its findings?
Yes, Sean.
Yes, Your Honor.
All right, then the court will find that it says opinion. It's my opinion that Ms. Tubbs is competent to stand trial.
Yes, Sean.
Okay, then it says at the last paragraph says, while I recognize the ultimate decision in this matter rests upon a judicial determination, it's my opinion that Ms. Tubbs was competent to stand trial at the time of this evaluation. You both stipulate to both of those findings?
Yes, Sean.
Yes, Your Honor.
All right, then the court will sign an order. Is she receiving medication? Is she?
She's in the Calhoun County Jail. I don't know yet.
Ms. Tubbs, are you receiving medication?
No, Your Honor.
No medication? All right.
No, ma'am.
And counsel, are either you aware that she's receiving medication?
I am not aware, Your Honor.
I am not aware, Your Honor.
I don't see any mention of medication here, so. All right, and I'm signing the order finding her competent to stand trial. And do we have a trial date on this matter?
March 17th.
What date?
March 17th.
Okay, so this matter is scheduled for March 17th at 9 o'clock. Has counsel had a chance to discuss whether this matter is going to be resolved or not?
Your Honor, I had filed a notice of insanity to get a criminal responsibility report. I have not received that yet. Once I get that, I'll have a good idea as to whether we're going to be able to settle this or whether or not we have to go to trial.
Your Honor, I object on that. I would like to exercise my Sixth Amendment right, and I would like to reserve my rights to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of compelled benefit under any unrevealed contract of the commercial agreement. And that's under Code UCC 1-207. And I have the rights to represent myself and waive all counsel knowingly, willingly, and intelligently.
Skeptical about the intelligent part, but credit where it's due. She knowingly walked straight into trouble by asking to represent herself with a clearly low IQ.
And I would like to.
Right, so you're requesting that you be allowed to represent yourself? Is that what I'm hearing?
That's correct.
All right. Well, then I'm going to voir dire you with regard to that decision. Would you like an opportunity to speak with your client in the breakout room with regard to this decision, counsel?
Well, she said that a couple of times, but I would ask that the court hold off on that till I get the criminal responsibility. So, if once I get that, then if she wants to represent herself, then we can,
Well, ma'am, do you want to do are you saying you're not going to do the criminal responsibility evaluation?
I do not need to do any of that, sir.
I'm sorry,
that's defamation of character. I will not be doing any of that. And I would like to exercise.
You are requesting that you not do a criminal responsibility evaluation. Is that my understanding, ma'am?
That is your understanding. Correct.
Well, yeah, with the MIDC's policy, I don't know if I can continue as her attorney of record. She has to have standby counsel appointed if she's going to represent herself. That's my understanding of their current policy.
All right, and you do standby counsel?
No, yeah.
All right, well, would you like to talk with her before she makes this decision? I'd like to have you speak with her.
Yes, Sean.
So, ma'am, I'm going to have the attorney go into a breakout room with you and just talk to you. This is a very important decision. I'm not saying I'm not going to do it, but I just want you to talk with him and understand some of the risks of doing this. And okay?
Your Honor, I understand all the risk and I do not wish to talk to him. I have not talked to him in 6 months. So
Haven't spoken to your lawyer in 6 months doesn't mean he hasn't mastered more legal knowledge than you ever will.
I pray you respect my wishes.
So just so I'm clear, you're refusing to talk with him. Is that correct?
Correct. I understand all the consequences and repercussions in this case.
Okay. All right. Then let's, ma'am, we're going to need you to have you sworn in for you to self-represent yourself. Okay. I want to ask you some questions just so you understand. Can you swear her in, please?
Ms. Tubbs, please raise your right hand in front of the camera where we can see it.
I do not swear in, but I wish to tell the truth and nothing but the truth.
All right. Then will you affirm?
I am here to, I'm here
All right,
to reserve
let's
my
have you
right.
raise your hand and you can affirm, okay?
Do you solemnly swear to?
No, do you solemnly affirm?
Do you solemnly affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth.
Okay, you have to put your right hand up, ma'am, please. Let's do it again.
That's against my religion, sir.
All right, then ma'am, I'm not gonna have you self-represent you until you do this. So if you're not gonna do it, we're gonna continue the attorney with you, all right? So you tell me what you want to do, Ms. Tubbs. Because until I go through these questions with you under oath, we're not signing any, we're not having you present yourself.
What oath am I going under, sir? I have the right to know what oath I'm going under because I don't go just under any oath.
All right, well, let's have her raise her hand again and you say the affirmation. It's not an oath, it's an affirmation. Raise your right hand, please, ma'am.
Do you affirm?
No, yeah, okay.
Do you affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth, and I come in as beneficiary, affirm.
All right, thank you, ma'am. What's your name?
I am the beneficiary, Tanea Nicole Tubbs.
All right. Do you understand that you have a right to have a lawyer represent you in this case?
Yes, sir.
Do you understand that I will appoint a lawyer to represent you if you cannot afford a lawyer?
I waive that right.
Huh?
I understand what you're saying, but I waive that right.
Okay. Do you want to have a lawyer represent you?
No, sir.
Can you afford a lawyer?
Yes, sir.
Okay. What is the maximum sentence in this matter, Madam Prosecutor?
In this matter, Your Honor, it is
Punishable up to 5 years or a fine not.
Ma'am, just wait. Let me speak, okay?
I'm sorry.
it would be 7.5 years because the defendant, it's carrying concealed weapon, which is a 5-year maximum penalty, but there is a habitual second offense notice. So that would increase the penalty to 1.5 times the maximum sentence, which would put it at 7.
Sometimes I wonder if these people grasp what it really means to represent themselves. On one hand, they risk 7.5 years in jail, and on the other, they trust some random advice they found online. Yet, they keep choosing the internet over common sense.
Possible sentence in this matter is 7.5 years because you are a habitual offender second offense notice. So it's 7.5 years is the maximum sentence. Would you like to talk with a lawyer, with a court-appointed lawyer to decide if you want to represent yourself or not?
No, I would like to represent myself and put in the motion to dismiss.
Okay. So, ma'am, first of all, can you give me your educational background?
Might as well be a certificate from CRAYOL.
I have
How far have you gone in school, ma'am?
college.
College, okay. And have you represented yourself before?
Yes,
And why do you wish to how many times have you represented yourself?
twice.
Okay, and then what were those in criminal matters?
One is, yeah,
And what happened with that case?
I got it dismissed.
Okay. And what was the other case you represented yourself, Ms. Tubbs?
I'm actually doing that now. It's for another criminal case, actually.
And you're representing yourself in that case?
Yes.
And why do you wish to represent yourself in this case?
I wish to represent myself in this case because I have learned all the trade secret acts, and I'm fairly fed up with how this courtroom is operating and suing people without letting them know that they are entering into a contract with you all as owning our vessels, and I'm tired of it. I'm tired of it. No one owns me.
All right, ma'am, tell me what the elements of this offense are.
The elements of this offense is that it's punishable by imprisonment for more than
No,
five.
that's not what the elements of the offense are.
The elements? What do you mean
Yeah.
by elements? Because you know y'all.
Well, that's the problem. You don't know.
Double language here, so I know.
How are you going to represent yourself if you don't even know the elements of the offense? How are you going to do that, ma'am, if you don't even know what you have to defend against?
I have to defend against the accusations, the charges.
All right, ma'am, tell me what the rules of, do you know the rules of procedure?
The rules and procedures to this is that, yes, that a prosecutor, the people of the state of Michigan is trying to sue my corporation. That's correct, right? And you are acting as a trustee, correct? Y'all acting as judges and acting as trustees, correct?
No, I'm elected as a judge. I'm not a trustee. I'm a judge. Okay, ma'am.
Okay, so what?
Ma'am,
so
no,
what?
you don't get to quiz me, Ma'am. What do you know? What the rules of evidence are?
Yes.
Okay, tell me what the exceptions to the hearsay rule are.
Acceptance of the hearsay. Hold on, I want to write all this down.
Writing this down. There's no quiz. The judge is just using your own ignorance to show why this is a bad idea. For context, privilege exemptions usually fall into two categories under Michigan Rules of Evidence 801 to 806.
Asking you, you say you know this stuff. How are you going to represent yourself?
You got acceptance of hearsay, sir. I would like to write everything you're saying down so I can be able to.
Have you ever done jury selections or jury instructions?
Yes, jury, it holds up to 12 people.
No, do you know how to ask them questions?
Yes.
And how to do the jury instructions? All right. Do you know how to preserve issues for appeal?
Yes.
Do you know that self-representation is almost always unwise?
Yes.
Did you know that the first day of law school, they tell us that he who represents himself has a fool for client? Do you know they tell us that?
Yes.
And so what does that tell you if they say he who represents himself has a fool for client? What's that tell you, ma'am?
You know what it tells me?
Yeah, what's that tell you?
You all operate in trade secret acts.
Okay. Well, that's not true, but okay. Miss Tubbs, would you do brain surgery on yourself?
Why would I do brain surgery on myself?
Yeah, because you'd have a fool for a patient, wouldn't you?
Correct.
Exactly. If you wouldn't perform a risky surgery on yourself, why would you handle a criminal case alone when your entire future is on the line?
So why do you think you can do law if you can't do medicine?
because I go by federal law.
Okay. You understand you'll receive no special treatment and you can receive no help from the judge during the trial. You understand that?
I understand.
You understand the prosecutor is an experienced trial lawyer who is unlikely to give the defendant any special consideration. Do you understand that?
Yes.
You understand you'll receive no special help from the court staff and you'll be expected to follow the same requirements that apply to practicing lawyers. You understand that?
Yes.
Madam Prosecutor, have I complied with MCR 6.005?
Yes, Your Honor.
All right, ma'am, do you believe that your waiver of an attorney is knowingly, intelligently, and voluntarily made?
Correct.
And accurately and understandably?
Yes.
Okay. Then the court will find that the waiver is knowingly, intelligently, voluntarily made. The waiver is unequivocal. You understand the disadvantages of self-representation, and self-representation will not disrupt, unduly inconvenience, or burden the court. So I'm going to grant your request to represent yourself, ma'am, okay?
Thank you.
All right. Now we've got a jury trial. What's our date?
And I would like the full discovery package sent to me, please, as well with along with the Dr. Chef report and the oath of office, please, so I can know what I'm dealing with.
To represent yourself, you must follow the same rules as everyone else. Everything you request has to be filed as a motion, just like any real lawyer would.
Do you guys go by maritime law or common law?
Ma'am, it's not maritime law. You need to learn the law, okay? I'm not advising you on the law. I told you I'm not advising you. If you don't know what it is, that's up to you to find out. I'm not advising you on anything on the law, ma'am.
Don't worry about it. I know what it is.
Yeah, don't ask for any special consideration. You have to perform just as any licensed attorney would here. So if you don't know that, I would strongly recommend you have an attorney represent you if you don't even know if it's a maritime law or not.
It's my right to ask questions.
All right, well, go ahead. As I said, he who represents himself, he or she is a fool for a client, ma'am. Okay? We will have the attorney send you those documents. Madam Clerk, if you can get a standby counsel for this for March 17th at 9 o'clock. Is there anything else we need to take up?
So am I here released?
Yes, you're released.
Thank you, Your Honor.
But you need to send all the materials to her. And also, if we can get her brought here from the jail, Madam Clerk. Okay.
That's what I was going to ask for, is to have her written here and then another date before the trial date where standby and Ms. Tubbs would be here, where we would all be on the same page.
Well, we're going to get the standby and do that right away as soon as we get that.
Okay.
I
We can
request
schedule this for, ma'am, don't interrupt me. I don't interrupt you. You don't interrupt me.
Excuse me.
We'll schedule this for February 19th at 9 o'clock for assignment of a standby counsel, okay? And if you can make sure that she is on Zoom that day, Madam Clerk. Okay. Is there anything else we need to take up with regard to Ms. Tubbs' gig? And you, ma'am, just so it's clear, you're under oath. You are requesting that there not be an insanity defense. Is that correct?
That's correct.
There's a saying that in a crazy world, the sane ones seem insane. Sovereign citizens live in a world of their own making. For today's final hearing, we have a sovereign citizen, Karen, who also calls herself an anon and refuses to acknowledge paying debts, applies to her.
There is LVNV Funding LLC versus Ruth Conway, case number 244008GC. Is counsel here for the plaintiff?
Yes, Judge Hillman, Cezanne Barda.
Well, you're an attorney, sir?
Yes, sir.
Oh, okay. All right. I couldn't tell based on the way you're dressed. we do expect lawyers to wear ties and suits for court proceedings, Mr. Barta.
Yes, Your Honor, I completely apologize. There are two attorneys that handled our docket via Zoom today. Both failed to appear. I don't know why, and now I'm scrambling. I apologize.
Okay, all right. Is Ruth Conway present?
Yep.
Okay, good afternoon. All right, so this is plaintiff's motion for summary disposition. Ms. Conway, the plaintiff filed a request to have a judgment granted in this matter. Mr. Barta, do you wish to proceed?
Yes, Your Honor. Our motion is based on MCR 2.116 C9 C10. We don't believe there's a genuine issue of material fact to move forward to trial. This is a straightforward collection matter whereby it was original creditor of Credit One Bank. LVNB purchased that, and all the chain of title and bill of sale documentation is attached to our motion. We also have billing statements showing charges made and payments made, which comports with the account stated theory in the state of Michigan. The address on those billing statement matches the same address where the proof of service went for this file. And we also have an affidavit from our client stating how much is owed at this time. Defendant not only failed to file a response to our motion for summary disposition, but also failed to file a counter affidavit, which is required by court rule. And even looking at her answer, all she states is she doesn't believe that this is her debt. I believe that plaintiff has provided proof and has established that this account was the defendant's, and I don't believe there's been there hasn't been a defense raised to be able to prevail at this time. Plaintiff respectfully requests that our motion for summary disposition be granted.
Okay. All right, Ms. Conway. So I have this motion for summary disposition that was filed by the plaintiff back on December 17th. I don't have any written response that was filed by you. I see you're holding up some kind of a receipt. I don't know what that's a receipt for, but we did receive your answer to the complaint. What date is on that receipt that you're holding up, ma'am?
October 29th.
Okay, so I think you're referring to your answer to the complaint that you filed in this matter, which was dated, let's see, which is dated October 28th. So I'm guessing that what you're holding up is verification that you filed an answer to the complaint. However, there was a motion for summary disposition, and basically
I never got that. I never got that.